I'm going to ask Anamika to please take charge and commence her presentation.
Hi everyone, I'm Anamika. I'm an advocate, and today I'll be covering basically the Ngt Act, what the Ngt can do, what are its powers, in what situations should you go to the Ngt as opposed to going to the High Court or any other court or tribunal. And after I go through the Act, I'll also walk you through the format of an Ngt application or an appeal. How it differs from the High Court petition, which Norma ma'am had spoken to you about yesterday. After that, I'll also take you through a High Court petition. Both of these have been shared with you previously. So you can sort of refer to that as I'm speaking, and I'll show you what the differences are in the formats, in what you have to sort of put in, the information that you have to share. And lastly, as Sir said, after the session is completed, we'll have a short practical exercise. Earlier, the plan, of course, was that people would draft their own petitions, but because of this whole COVID thing, we've had to change things around a little bit. Now we have a different practical exercise where I've given you 3 separate factual situations. I've given you some legal information, which is sort of like a clue or a hint for you in terms of how you have to approach it. And then there are 4 questions after each fact situation for you to answer. It's slightly more objective, but it covers stuff that has been spoken about in the previous sessions, especially what has been spoken about by Claude and Norma, which is in terms of drafting a demand for justice letter as well as approaching the High Court. So what I'm going to talk about is the National Green Tribunal and the National Green Tribunal Act, which is the act under which the NGT is empowered to do what it does. So firstly, what is the National Green Tribunal? What is it? It is a specialized judicial body with the expertise to adjudicate upon environmental issues. The reason that this NGT even came into being was because there was a recognition of the fact that we need a specialized tribunal because of how multidisciplinary environmental issues can be. You need technical expertise when you adjudicate these issues. So they decided that because of these multidisciplinary aspect of environmental issues, it would be better to have a specialized forum just to deal with environmental disputes. There was also recommendations of the Supreme Court. There were recommendations specifically about this from the Law Commission of India. And also, of course, India's international obligations because of the United Nations Conference on Environment and Development, which happened in 1992, where all of the participating countries took a decision that they would essentially take up on the obligation to develop national laws about environment and implement those laws specifically. So, in order to ensure that we comply with our international obligations, we came up with the Ngt Act, because the Ngt essentially is to ensure the proper implementation of our environmental laws and policies. Now, the Ngt was established in 2010 after the Ngt Act came into being. Fun fact, since the Ngt was established in India, India is the first developing nation to actually have a specialized tribunal for environmental matters. And even in the developed nations, only Australia and New Zealand so far have a specialized tribunal as such. So even in the entire world, we are the 3rd country to have something like this. Okay, so now I'll go into the next part of it, which is the composition of the Ngt. So now, in the High Court, we have judges. We only have judges. You have benches of different strengths, which is that you could have a single judge, you could have a division bench, which will have 2 judges, and so on. In the Ngt, you have something that is slightly different. You have judicial members and you have expert members. The Ngt composition is such, there is one chairperson who is the head, who is a retired Supreme Court judge. And then you have judicial members who are retired High Court judges. And then after that, you have expert members. Expert members are people who have professional expertise, I believe, of at least 10 to 15 years in the field of environment and wildlife conservation and so on. This is so that aspects that are beyond just the legal field can be looked at by the expert members, and the technical aspects also can be dealt with thoroughly. After this, we have what is known as the Territorial Jurisdiction of the N.G.T. Here you can see that basically to ensure that there is an N.G.T bench that is available for everyone, no matter which part of the country you are in, they have set up multiple benches of the N.G.T. So I think if you can see the PPT, you'll see that we have different zones. There is the northern zone, western, central, southern, and eastern. Each of these have a different place of sitting. So your northern zone, which is your principal bench, is in Delhi. Then you have the western zone, which is where Goa falls under, sits in Pune. And then you have the central in Bhopal, the southern in Chennai, and the eastern in Kolkata. Within each of these benches, they have their own states that fall within that jurisdiction. So for example, you can see that the western zone, which sits in Pune, has Maharashtra, Gujarat, and Goa. So before you file anything before the N.G.T, you have to wait, see which bench you fall under, and make sure that you file your application before that very bench. Otherwise, your application will not be entertained because you would be filing it in the wrong jurisdiction. So, I mean, as far as you are in Goa, remember that you have to file it in the western zone, which is in Pune. Next, we go into the powers of the N.G.T. Now, this is important because this speaks of what exactly the N.G.T can do. Remember, the N.G.T is set up under the Ngt Act. So its powers are all limited and are all explained in the Act itself. The N.G.T cannot do something that is outside the ambit of the Ngt Act. Now, the powers of the N.G.T fall within 3 sections. Now, this is broadly what I'm going to cover in this talk. These 3 sections are very important. So section 14 tells us that the N.G.T is empowered to settle environmental disputes. Section 15 tells us another aspect, that the N.G.T can provide relief, compensation, and restitution, again with environmental issues, of course. And then section 16 tells us that the N.G.T has appellate jurisdiction over certain orders, directions, or decisions, which means that over certain orders, the appeal against that order would lie with the N.G.T. So I'm going to quickly go through each of these sections to explain to you what they mean, some nuances that are within each of them, and the limitation period that falls within each of these sections. So we'll first start with section 14. Section 14 basically says that the tribunal can settle disputes. It says that the tribunal shall have the jurisdiction over all civil cases where a substantial question relating to the environment is involved, and that such question arises out of the implementation of the enactments specified in Schedule 1. So there are 2 parts to this section. The first, of course, is that it shall have jurisdiction over all civil cases where a substantial question relating to the environment is involved. What does this mean? Substantial question relating to the environment is, in simple words, an environmental issue. But this has been explained in detail in section 2M, where this is defined, where it says to include instances where there is a direct violation of a specific statutory environmental obligation by the community at large, which basically means that there is a violation of some environmental law, or the gravity of the damage to environment or property is substantial, or damage to public health is broadly measurable. It also includes instances where environmental consequences relate to a specific activity or a point of source of pollution. Now, this definition basically is inclusive, it is wide, it is not exhaustive. That is to say, even instances that do not fall within this specific definition of substantial question relating to environment, as long as they are largely environmental issues, would sort of fall within this. Simply, it just means that there is an environmental issue or some environmental aspect is being talked about. Now, the second issue is that the second part of this provision is that the question should arise out of the implementation of enactments specified in Schedule 1. Schedule 1 is now on your screen. This is the schedule that is annexed to the Ngt Act. You will see that there are 7 acts that are noted here. There is the Water Pollution Act. There is the Water Pollution Cess Act. Then you have your Air Pollution Act, Forest Conservation Act, the Environment Protection Act, the Public Liability Insurance Act, and the Biological Diversity Act. There are only 7 acts that are listed here, and only issues that arise out of the implementation of these 7 acts can come before the Ngt. So largely you would think that these are all the environmental acts in the country, but you should note that there are there is one very important and what you would think is an environmental act that is not here, which is your Wildlife Protection Act. There is also the Indian Forest Act that is not here. You'll also see that the Trees Act, which is in Goa, we have a Goa Trees Preservation Act, which is also not here. So there are only certain specific environmental laws that go before the Ngt. So before you file a petition before the Ngt, please check that the act that you are relying on, the act that you are referring to, or the act or the violation of which you are talking of, falls within this schedule. Now, this also includes, of course, notifications that have been issued under these acts. So, for example, we have the CRZ notification or the EIA notification, both which have been issued under the Environment Protection Act. So, CRZ issues, EIA issues again will lie before the Ngt. Now, apart from this, we have to remember that there is a section 29 in the Ngt, which basically bars the jurisdiction of other courts in situations where the Ngt has power. Which is why if you approach the wrong court, the first thing that the other side will come and say is that you have an alternate remedy. So for example, if I take a CRZ issue and I go to the High Court, the first objection that the respondents will have is that my actual remedy is to go to the Ngt as per the Ngt Act. And as per section 29 of the Ngt Act, I am barred from coming to any other court. This will be the first thing that they come and say, and in most situations, the High Court will agree with that and send me packing to the Ngt and not take up my case. Now, of course, the High Court and the Supreme Court still have their writ jurisdiction, and that cannot be taken away by the Ngt Act. So there are certain situations where if there is an extraordinary circumstance, there is an enforcement of a fundamental right that I am seeking, and I can explain why the High Court should take up this matter. In those certain very, very specific cases, the High Court may consider it under its writ jurisdiction. But in most situations, that will not be. And in most situations, you will still have to go to the Ngt. Most simple matters that come up from any of these acts that are in Schedule 1, please go straight to the Ngt. Otherwise, as ma'am said, you'll be wasting your time. Because the Ngt has been set up specifically for these issues. Okay. Then we go to the next thing, limitation. What is limitation? Limitation basically means it's sort of your deadline to file your application before the court. The limitation period, the cutoff period basically for under section 14 is 6 months from the date on which the cause of action first arose. What is cause of action? Basically just means the thing that happened which is causing you to file this application. For example, if it's illegal construction, the date on which it started, or the date, at least on the date that you first notice it, would be the date on which the cause of action arises for you. Within 6 months from that date, you will have to file your application before the Ngt. Now, the Ngt has an aspect for condonation of delay. You are granted a 60-day grace period, if you may call it, after the 6-month period gets over to file your application. If you can explain to the Ngt that you had legitimate reason for which you couldn't come within that 6 months period and you've come within the next 60-day grace period. Remember again that here you will have to, with your original application or your appeal or whatever you're filing, you will have to file a separate application called an application for condonation of delay. Here you will have to properly explain why you are late, what caused the delay. Whatever the reasons are, they must be legitimate. Ideally, you should have some documented proof for why you were late. For example, you were waiting for RTI documents. You should be able to show that you filed your RTI application as soon as you came to know, and that delay was not from your side but from the side of getting the documents or something like that. You will have to have a legitimate reason. Within this 60-day period, the NGT can condone your delay, which means that they will have a hearing, they will hear you out, you will explain why you were late. And if they think that your delay was legitimate, they'll grant you that grace period, and then your application will be accepted for hearing. However, if you come beyond the 60 days, that means you are later than 6 months and 60 days, even the NGT does not have the power to condone your delay anymore, because the NGT is getting its powers from this act. The NGT is only empowered to condone your delay beyond 60 days, within 60 days, not beyond that. Okay? So make sure that you keep these dates in mind, you keep these limitation periods in mind before you file an application before the NGT. Next, we will go on to the next section, Section 15, which deals with relief, compensation, and restitution. This section tells us that the NGT is empowered to provide relief and compensation to victims of environmental pollution and other environmental damage. They're empowered to provide restitution of property that is damaged and for restitution of the environment. Now, please remember that when they say restitution of property damaged, all of this is all within the ambit of the acts that we have spoken about in Schedule 1. So even your property that is damaged, there must be some environmental cause. Your property must be damaged out of the implementation or the non-implementation of one of the environmental enactments. There has to be a substantial question relating to the environment when you are seeking relief, compensation, or restitution under Section 15. Now, limitation period for Section 15 differs from Section 14. Here, applications must be filed within 5 years from the date on which the cause of action arose. Again, you have a grace period, which is the same, which is 60 days. So here, your time period is slightly more than if you come under Section 14. But under Section 15, you can only come for these things. Where there is an environmental dispute, it has to be under Section 14. Next, we go to Section 16, which speaks about the appellate jurisdiction of the NGT. What is appellate jurisdiction? What does that mean? Appellate jurisdiction basically means that when there are certain orders or directions or decisions of the government, which if you want to challenge, you have to come to the NGT. Regularly, I think we would have gone to the High Court before the NGT came about, or each situation differs. Like, for example, if you want to appeal a consent that is given by the Pollution Control Board, you usually have to go to the Administrative Tribunal. But now that the Ngt Act has come into being, it tells us about the appellate jurisdiction that the NGT has and in what situations the appeal lies before the NGT. So you'll see that I have not put in the entire Section 16 here. There is certain nuance that is there within the Act when it says about orders that are passed under the Water Act or the Water Cess Act or the Air Act. It tells you particular sections under which those orders should have been passed. So largely you can see the acts that are here. They are more or less the same as those that are in Schedule 1. Except you will see that the Public Insurance Act is not here. But largely orders that are passed under the Water Act, the Air Act, the Water Cess Act, Forest Conservation Act, Environment Protection Act, and the Biological Diversity Act all have appellate jurisdiction to the NGT. So tomorrow, if the GCZMA issues a demolition order against your house or something like that, don't go to the High Court. Your appeal against that order will lie before the NGT first. Next, again, limitation period for Section 16 is different. Here it says that appeals must be filed within 30 days from the date on which the order or decision or direction is communicated to you. So this is important because your limitation period begins from the date that you received the order, not necessarily from the date that the order was passed. It is from the date that you received the order that your limitation period of only 30 days begins. And again, there is a condonation period of 60 days where you will have to file an application for condonation of delay that will be decided by the NGT on its merits. Don't go beyond this 60 days, the NGT won't be able to do anything. And lastly, as the last provision from the Ngt Act that I am dealing with, is the appeal to the Supreme Court. Section 22 basically says that if you are aggrieved by an award or an order of the Ngt itself, then what do? Where do you go? You go straight to the Supreme Court. And you have to do this within 90 days of the date of communication, which basically means the limitation period under this section is 90 days. But unlike the Ngt, which gets its powers from the Ngt Act and cannot condone a delay beyond 90 days, the Supreme Court, of course, has more powers than that. So if you can manage to convince the Supreme Court that you had legitimate reason, it may even entertain your appeal beyond this 90 days, because the Supreme Court, unlike the Ngt, is not bound by the Ngt Act. Now that we have gone through the entire Ngt Act, I mean, of course, not the entire Act, I have only taken certain provisions that I think are important for you to understand, mainly when to go to the Ngt, and when you go there, what can the Ngt do. There are many other provisions. The Act is more or less quite simple, so you can actually read it by yourself also. And if you have any questions, please feel free to write in and maybe we can get back to you if I have not covered something here. Lastly, I'm going to deal with the format of an OA or an appeal that you file before the Ngt. On the last lecture that Norma ma'am did, she dealt with the High Court and the PIL and what all is there within a PIL. Now you'll see that the format of an application before the Ngt, though, I mean, technically what you will be saying largely is the same. You will have the facts and you will have the grounds and so on. The format is slightly different. So unlike the High Court, where you only have one volume essentially, where you have your petition and then you have your annexures, when you file to the Ngt, there are two volumes that you have to submit separately. Volume 1 will be your application or your appeal, and volume 2 will be your annexures. So as you can see on the PPT in front of you, you'll see volume 1 OA or appeal, and then at the end volume 2 with an index. You will have to put a separate index on top, which will which will deal only with the annexures. So you will have annexure 1, so and so document from page this to page that, list of all of your annexures separately in that volume 2. Now I'll go back to volume 1, which is your OA or your appeal. I'm just going to run through this with you, and then I'll open up the actual OA that I've shared with everyone, and we'll go through that section by section. So of course, you will first have your index, after which you will have your list of parties. This is more or less the same as the High Court, which will basically just tell you who the petitioners are, who are the respondents, and so on, which court you're filing it before, and all of that. Now, third, this is something that is different in the Ngt, where you will have to explain what is the substantial question relating to the environment that you have come here before, especially if you're filing it under section 14. You will have to explain what is the substantial question relating to the environment, essentially what is the environmental issue that you have come for. Also detail which act that you're relying on and that it falls within the schedule that is a part of the Ngt Act. Then you come to 4, which is issues before the tribunal. Here you literally have to list in 1, 2, 3, 4 the issues, the legal issues that the tribunal will be examining. And then number 5 is the same as the High Court. You list the facts of the case. Basically, in a chronological manner, you tell it like a story. On so and so date, I saw this. Then we filed an RTI act and we filed an RTI application and we got so and so documents. You can explain what the documents are, and you give the whole factual situation that is giving rise to your cause of action or whatever problem you're dealing with. After that, you come to the grounds, which, as ma'am also explained, same as the High Court. Your grounds are essentially the legal part. What are the laws you're relying on? What is the law that has been violated? You'll have to explain all of that in the grounds section. 7 comes the limitation. Depending on which section you are filing under, whether you're filing under 14, 15 or 16. As I explained, limitation periods for all 3 of these are different. you will have to explain how you are within limitation. If you are within that limitation period, you say that this application has been filed within the limitation period, which is so and so days, when the cause of action arose, when what all you did in pursuance of that, and when you filed the application finally. If you are not within limitation period, here again you will have to explain why you are late, that you fall within the 60-day grace period that is given, and that you are filing an application for condonation of delay along with your OA. Remember that if you are beyond the original limitation period, the registry itself will not take your application unless it comes along with a condonation of application for condonation of delay. It won't even go beyond the objections place for you to get your application registered unless you have that application for condonation of delay along with your OA, if you are beyond the limitation period. After that, we come to number 8, which is your prayers. Again, basically same as the High Court. Your prayers are what relief you're seeking from the NGT. What is it that you want the NGT to do? You want them to quash some order, you want compensation, you want relief from some illegal construction. That will have to be listed in your prayers. And last, of course, is your verification or your affidavit, which is basically the same as the High Court. So what I'll do now is I'll just open up that Ngt application that we've shared with you. Whoever has access to it, I'd suggest that you open it up too, so that you can see what I am reading out as I do it. So now this is basically, if you look at your screens, is the Ngt application that we had shared with you earlier. I'm just going to go through it section by section. So first, now this is to the Ngt. So I have two compilations, compilation 1, compilation 2. My volume number 1, basically, I have an index for that. This, as you can see, only has my memo of application and my verification. That's all that is in my index for the first volume. I go down and here we go. So here on top it says before the Ngt Western Zone at Pune. In your High Court petition, it would say before the High Court at Bombay, High Court of Bombay at Panjim, so on. Application number, whatever, of whatever year. And now under that, it says under sections 14, 15 and 18 of the Ngt Act. I have not covered section 18, but section 18 basically just speaks about filing applications or appeals before the Ngt Act and gives you some information about the procedure and so on. Under sections 14 and 15, which basically means that I am filing it with regard to a dispute, an environmental dispute, and 15 basically means that I am seeking some sort of relief in terms of am I seeking restoration, restitution of the area, maybe I'm seeking compensation. So it comes under section 15. Between, now here you can see this is the array of the parties, where here we have 3 applicants. You can have 1, you can have 3, you can have 5, how many ever applicants you have. You will have to list them with name, address and so on. And then you go down and here are your respondents, which will basically be your authorities, or if there's a private party that you're filing against. You can see here there is the state of Goa, there is the GCZMA, you have the Biodiversity Board, you have the village panchayat of the area, and then of course you have one private party who is allegedly doing what we said was illegal. Now this is the actual body of the application. Okay, so you have addresses of the applicants and so on. Look at para 3. This is important. This is where we explain what is the substantial question relating to the environment. Here it says the application deals with a substantial question relating to the environment, namely ecosystem damage caused by illegal reclamation and dumping of mud in a CRZ1 area. So basically here the law that we are the violation of the law that we are dealing with is the CRZ notification, which comes within your Environment Protection Act and hence of course falls within Schedule 1, which is why I'm going to the Ngt. My substantial question relating to the environment is ecosystem damage in the NDZ area, which falls within the CRZ notification. Then of course we say that no approval has been granted by the authority, which is the GCZMA. This paragraph essentially, in a sense, sort of summarizes what your case is about, explains how the Ngt has jurisdiction over it, and yeah. And then the next para, of course, also goes on to sort of give you a brief I should be able to read the first few paras of the application and know what the application is necessarily about and what I am going to be seeking, sort of in a summary manner. If you look at para 5, it explains what I have come to the tribunal for. Here I say that we have come to the tribunal for a direction to remove the constructions that have been done in survey number so and so, which according to us are NDZ areas. We are asking for restoration of the damaged bunds around the Khazan area and restoration of the entire area back to its original conditions, which is why now my application is under section 14 as well as under section 15 of the Ngt Act. Then I go to the next section which I explained to you, which is the issues before the tribunal. So here again in point by point form, these are just the questions that the Ngt will be examining. Whether any construction or dumping of mud and so on can be carried out in a CRZ area, which is Khazan land and where there are mangroves, while there is a specific bar on it under the CRZ notification. This is one issue that is caused by this particular fact situation. And like that, B and C are again issues that we want the Ngt to go into. And D, whether the applicants are not entitled to complete rehabilitation of the disturbed area. Under section 15 this will come, where I am asking for restitution of the property of the area. Next we go into facts of the case. This is largely the same as the High Court petition facts would be. Literally it just explains who the applicants are. It gives a sort of detail of the land that we're speaking of. Where is that land? What survey numbers? The nature of the land, that it is Khazan land. And then it goes on to give you the rest of the factual situations. I'm not going to go para by para for this because it's very long. Please read it. I'm going to go straight down to the next bit, which is your grounds. So this is the full story, when we came to know what all happened, which authorities wrote what site inspections were done, so on. All of these give us more information and strengthen our application. Tomorrow, the entire story should be within the application. I think ma'am also spoke about this, is that whatever you want to produce before the court, whatever you're going to be relying on for your arguments, all should be down in your application and in your affidavits that you file and so on. But mainly, everything should be in your original application. This is basically the document that your entire case is based on. This is what the respondents will reply to and all of that. So whatever documents you think are necessary, of course, please exercise some caution and application of mind. Don't put in all the documents without going through them and seeing whether they're relevant or not, because in the end, you'll end up wasting a lot of paper and your own money. So think about it, but put everything that is relevant should be there in your application. Okay. This goes on and on. Aha, here we go. Okay, so para 37, we finally reach the grounds. This basically means I have told you the full story about everything that happened. And now I'm coming to tell you what are the legal grounds on which my application is based. Sure, factually I may be wrong, but I can only approach the tribunal if there is a violation of law. You can only approach a court if there is a violation of law. So in my grounds, I will now explain what is the violation, what does the law actually say, and in what way has this party violated the law. So for example, here I say that the site is a CRZ1 area and is classified as a Khazan land. Thus, as per the CRZ notification, it is a no development zone. So this is my legal ground, that the CRZ notification classifies this as a no development zone. So you cannot develop here. You cannot have any construction here. You cannot destroy this area per se. So that of course becomes one ground. Second ground becomes that fine, even one is that it's an NDZ. Second, of course, is that it's a CRZ area. So if it is a CRZ area, you have to get permission from the GCZMA before you can do anything there. Even if it is a permissible activity, you still require permission from the GCZMA. No permission has been granted by the GCZMA for this activity. Becomes my second ground, my second legal ground to be able to approach the Ngt. And so on. We say that there has been damage to the area. Not only have they constructed or done whatever, they have damaged the area around it, which is what I'm asking for restoration for. That becomes my third ground, and so on. Basically, you list depending on, of course, what your situation is, what the fact situation is, you list your legal grounds. This is more or less, as I said, same for the High Court and for the NGT. Next, you come to the next section, which will be your limitation. Limitation, as I explained, is basically your cutoff time, your deadline to be able to file this application before the NGT. Again, here I say that the application is filed under section 14 and 15 and is within the limitation period. Now, 14 and 15 are two sections, but we know that 14 has a lesser cutoff, has a lesser limitation period, of course, than 15. So if I'm saying that it's within the limitation period, it obviously is under the limitation period for both of these sections. Then I go on to explain what I am seeking and sort of explains when I came to know, when the cause of action arose for me, and then sort of gives a chronological steps of everything I did leading up to this petition. Now, I've done this even though we are filing it within limitation. If you are filing it beyond the limitation period, you will have to explain a lot more and also give your application for condonation of delay. Okay, so here this is your whole story about, you can see many dates, about all of that, about when I came to know, when I filed the RTI application, when we got the documents, and so on. Okay, and then it says applications for directions to completely rehabilitate the site is therefore within time. And then we come to the last bit of the application, which again is the same as your High Court, which is your prayers. What are the reliefs that you're seeking from the tribunal? When you are seeking prayers, remember again to check what are the powers of the tribunal, what reliefs can the NGT grant you. Because if the relief that you're seeking is beyond the powers that are given to the tribunal under the Ngt Act, then no matter how well you argue your case, the NGT will not be able to give you that relief because the NGT does not have the power to do so. So remember this whenever you're filing a case, whoever you're filing it before, that authority or that body should have the power to grant the relief that you're seeking. So in the NGT, this becomes important because the NGT is not as empowered as a High Court or the Supreme Court, of course, and it gets its powers from a specific legislation. So you will have to check that legislation, ensure that the NGT has the power to grant you the relief that you're seeking, and then file. And now after your prayers, of course, the application has to be signed by all your parties. You have a verification or an affidavit, which you will have to get notarized. This is basically you swearing on oath that everything that you've said is correct. At least everything that you've put in are either facts that you know to be true or is legal information that has been provided to you and you believe it to be correct and true. Basically, at least you're saying that to the best of your knowledge, you have not lied at all within this application and that everything is true to the best of your knowledge. And that's it. Now we come to, so that's your first volume. That is your entire application with each of the little bits that are required in it. And then you come to compilation 2, which will have your annexures. So you'll see throughout the original application, whenever you're talking about something, if there is a document that sort of evidences what you're saying, you enclose that document as an annexure or an exhibit. This is again the same within your NGT or your High Court application. And here, then in this index, you will list exhibit number 1 is GCZMA site inspection report dated so and so, exhibit 2, exhibit 3, and so on. So you have all of your annexures in one place. And within this index, here it's not filled in, but you will have page numbers. So you'll have page numbers, say 100 to 110, 111 to 113, whatever. So that it's easy to locate where your document is at. If the judges want to look at it, or when the registry is checking for objections, the index is what they'll rely on. So this is the entire story within the Ngt Act, how to file your application, what your application should look like. Feel free to use the application that we've sent you as a sort of format or a template when you want to file or if you are preparing a draft. I will now open the High Court format and so quickly run through that and just show you the small things that are slightly different between these two applications. Can you see it? Okay. So now this is the High Court petition that we shared with you. It's a PIL that was recently, not recently, 2 years ago filed before the High Court. Here again, So here, where the NGT you said before, the National Green Tribunal at so and so, here you have in the High Court of Bombay at Goa, you have your PIL number, and then you have your index. Notice here that your index is complete. There is no volume 1 and volume 2. There is just one index, only one volume, where you have your synopsis and so on, memo of petition, affidavit, and right after that your annexures begin. So you only have one index within this one volume. Then after your index, you have a synopsis. This whole aspect is not there within the Ngt application. This is there only in the High Court. What I refer to as the preliminary pages, basically information that has to go out before your actual PIL starts. So first you have a synopsis and a chronology of dates and events. Synopsis, as the name suggests, is a synopsis of what your PIL is. It's a short summary of whatever your PIL is saying. Draft this well, because remember that sometimes judges, of course, may not have time to sit and go through your entire PIL before the matter starts, but they can read this and they may have time to look at this to sort of get an idea of what you are seeking from them, at least the first few hearings before you have sort of explained your case. So it's important to have a good synopsis that explains what your case is. Don't go off into a long story. Keep it crisp, but have all of your important points down here. And after your synopsis, you have a list of date and events. This again, remember what all is relevant for your case. All dates and all events, of course, may not be relevant. Again, I should be able to read your list of dates sort of like a story, which tells me that on so-and-so date, this happened, which was followed by this on this so-and-so date. And then on the rightmost corner, you can see that there's an annexure and page number, which basically sort of directs me to documented proof for each event that I'm talking of. Some dates and events may not always have an annexure, but where it does, it helps to have it listed right next to it. And after that, sorry, this is a bit long. We have something called points to be heard. This is largely the same as the issues to be considered by the NGT. There it comes within your main application where you have issues to be considered 1, 2, 3, 4. Here we have points to be heard, which is sort of separate from my actual writ petition, from my actual PIL, but it comes before it. But again, I have points to be heard in the exact same manner, which is basically what are the issues that the High Court has to go into. Then we have a list of the acts and rules that are being referred to. What are the legislations I'm relying on? Here, when you're filing a PIL, you will obviously always be relying on the Constitution of India, number 1. And you will then whatever specific acts come in here. So, for example, this is a case that dealt with illegal sort of submersion and extraction of illegal groundwater. So, we are dealing with the Goa Groundwater Regulation Act. This act is not covered by the Ngt Act, so I do not go before the Ngt, I come straight to the High Court. If I had put in a CRZ or something over here, then the respondents would come running saying, no, you go to the Ngt. But because the Goa Groundwater Act is not covered by the Ngt Act, I come straight to the High Court. Then there is an authorities to be cited, which is basically if I'm relying on any judgment of the High Court, any previous orders of the court, I would list them over here. Then I go down and here. This is where the actual PIL begins. I have whatever in the High Court of so-and-so PIL writ petition number. There is this before I file, of course, will always say dash of 2019 or whatever year. Once you file the PIL, the registry gives you a number, and all subsequent times that you file anything before you serve people or whatever, please put in your PIL WP number here. Because once the PIL number is given, all reference to everything will be by that number. So make sure that you put in this PIL WP number here before you serve parties or even in your own copy for better management. Now I list essentially in this format in the matter of, I first list provisions of the Constitution that I am dealing with. Article 21, my right to life, Article 48A and 51AG, which becomes your directive principles, and then Article 226 and 227 of the Constitution, which speaks of the High Court's writ jurisdiction. So here, because I am filing it under Article 21, I am seeking the enforcement of a fundamental right. I am filing a writ petition. Only the difference is that I am filing it in public interest. I am not filing it for my own benefit. And then I go down in the matter of the Goa Groundwater Act and groundwater rules. Again, I'm listing the acts that I'm relying on, and so on. Then you go down. This is just the format. Again, I have my array of parties. I have whoever my petitioner is versus I have all my respondents. Remember that when you're filing a PIL writ petition, no matter who your other respondents are, the state of Goa will always be a party. No matter how many other authorities you've joined, you will always have to make the state of Goa a party when you're filing a PIL writ petition. Okay, then you go down, and then I have the first section, which is particulars of the cause against which the PIL is filed. This again, sort of in a few paragraphs, you summarize your PIL and you explain to the court why you have come, what is your cause of action again here, what is the illegality that the court has to go into. You explain that in a few paras, and then you sort of, then you have particulars of the petitioner. You have to explain who you are when you're approaching this court. Remember, I mean, a PIL can basically be filed by anybody. The question of locus there is slightly wider, but it helps to sort of show the court that you are a public spirited person. Maybe if you filed PILs in the past, you can list those. If you've made complaints to the authorities about this, you can say that in this over here, and just sort of explain who you are. Then you explain who the respondents are. And then now we come to an important part, which is the declaration of the petitioners. This is important in a PIL. It's completely different from your Ngt application. It is also different from filing a basic writ petition before the High Court, which may have a similar format. These are certain declarations that you are making to the court when you file a PIL. First, of course, is that this petition is filed by way of public interest. That you do not have any personal interest in the matter. That is your first declaration. 2 is that you are bearing the cost of the litigation by yourself. Next is that adequate research has been conducted in the matter that are raised in this petition. So now, again, if you're filing a PIL on your own after this, feel free to take the declarations from this petition, but make sure that they're there in your petition when you file it. Now, number 9, I believe someone had a question about this last time also. The petitioners state that to the best of their knowledge, the issues in this petition have not been dealt with or decided, or that a similar or identical petition was not filed earlier by the petitioner on the same matter, either in this High Court or the Supreme Court of India, and that this High Court has jurisdiction to hear this matter. I think somebody had asked, ma'am, how would you find out, how would you know if somebody has filed a petition on this matter, or how would you know if this has been dealt with? Firstly, remember that your declaration is that you have not filed something. You have not filed the same case before. If, of course, do your due diligence and check whether, of course, a case like this has been filed before. Ask lawyers, like ma'am said. But if you do go to the court and say this issue has already been decided, the other party will come and say so. The court will inform you and your matter will simply be disposed of, or you will be given time to sort of consider what happened in that matter and see if your matter is different and so on. Your case will not be affected per se, but your declaration is that you have not filed something. If you have previously filed a similar case and have got an order in your favor or even against you, and you're trying to sort of come back to the court to argue the same issue in a different way, you will be hit by res judicata. And here what will happen is that your declaration then will be wrong, and your reputation, at least in the eyes of the court, will be lessened, where essentially then you would be lying to the court when you say that you have not filed something. So be careful in that regard. But it's not, I mean, of course, it's not up to you if other people have filed a similar case and it has been decided in some other court at some other time and all of that. That will not be held against you under this declaration, at least. Then, of course, the petitioners have understood that if any security is required to be furnished or any costs or charges, you will comply with the charges. These are just declarations that you have to make to the court, undertaking that you understand all of this, before you come in a PIL writ petition. Next, you come to the facts. Again, same as the NGT, just give the whole story about whatever has happened, explain who the people are, explain what the property or the situation is. And again, keep it largely to your facts. Try as far as possible to keep your facts and your grounds separate. That is, keep your factual situation and your legal aspects in different parts of your petition as far as possible. So this basically becomes your whole story of whatever has happened. Sorry, I'm scrolling down fast because it's not necessary to go through each of this. You can study this petition to sort of understand the whole, how it was drafted and all of that on your own time. I go down here and I will eventually reach the grounds. Yes, I have reached the grounds. Here again, like with the Ngt application, I will detail the laws that have been violated, the laws on the basis of which I am approaching this court. So for example, here, because we were dealing with illegal groundwater, as I said earlier, the act that I'm relying on is the Goa Groundwater Regulation Act. And here I explain what are the provisions of the act that are being violated. So for example, I say that as per section 5 of the act, no person can sink a well without the permission of the groundwater officer. Without this person's permission, nobody can sink a well, which basically means that if a well has been sunk without permission, it would be illegal and it would be required to be removed. And so on. So basically, I explain what the law is. There may be multiple grounds because there may be multiple provisions of the same law that are being violated. I list all of them. I put it all down. If there is a case that I am relying on, say for example, the Supreme Court has previously said something about this sort of a situation, which becomes my precedent for me to approach this High Court and get similar orders, I put that also in here. Alright, for example, here, I say here that the Supreme Court has held that underground water belongs to the public as a shared resource and under the public trust doctrine. Basically, that means there's a precedent in this regard. I'm not just saying it. The Supreme Court has said it before. So the High Court is likely to take it more seriously, of course, than if I say it. Then I go down. Here again, I refer to other cases where these things have been said. Using precedents, using other cases that a superior court has said is always helpful because sometimes the court may be bound by it. So for example, if the Supreme Court has directed something, the High Court cannot direct something that is contrary to it. But if I take something that another High Court has said, while this High Court may not be bound by it, it will definitely be persuaded by it more than, again, if I just said it, right? So it's good to try and find precedents that may be applicable. Whether for the High Court or for the NGT, any court, always look for precedents that may help your case. And then I go to the next part, which is source of information. This basically just means all of the documents that I'm relying on, all of the evidence that I have, where did I get it from? More often than not, it will be because of the RTI Act, because you filed RTI applications. If you found it online, you can say on which website you found this information and so on. Next, we come to delay, if any, in filing the petition. This is basically the same as the limitation part in the Ngt Act, where the Ngt, of course, gives you specific limitations for each specific thing that may not be there when you're filing a PIL writ petition. When you're filing a PIL, also delay and limitation is slightly more lax because you're doing it in public interest. But remember, of course, again, that you will have to explain why you have come late. If you have come late, you must have legitimate reasons for being late if you are. But here I am saying that there is no delay in filing the petition. Of course, I explained when I came to know. I felt the effect from Feb 2019, and then I immediately filed RTI applications. I made complaints to the WRD. Thereafter, I received my RTI application information, and because the illegality is still continuing, I am approaching the court. Now, remember from what I think Claude has dealt with, the demand for justice letter, that you would have informed the authorities of whatever violation is going on. You have written the demand for justice letter, and then you are approaching the court. Your first reaction is not to come running to the court. You have alerted the authority who is supposed to take action, but obviously that authority is not doing what it's supposed to do. So you are constrained to seek directions from the court, which leads me to my next section, which is representations made. You will have to inform the court of when you informed the authority, which authority you informed, and you will have to enclose that document as well. So here I say petitioner has made a representation to the concerned authority, which would be my WRD here, and I have enclosed the letter along with my petition. So your demand for justice letter is important, A, of course, to inform the authority, but B, it is a requirement when you file a PIL. Excuse me. Next, I go to documents relied upon. All of these documents are enclosed within my petition, so they will be in my index page. So I simply say that here, that the list of documents is in the index. And lastly, I come to the prayers. Same thing as the Ngt application. What are the reliefs I am seeking from this court? Whatever I am seeking, I list down. For example, here, for an order directing respondent number 1 to ensure the immediate closure of the bore wells that have been illegally sunk. I'll ask for them to cancel the registration because of the illegal activities. I may ask for damages. I may ask for pecuniary damages upon that respondent, and so on. Whatever it is that I believe that the High Court is empowered to do in certain situations, and that I have the factual and legal grounds to support the fact that I deserve to be granted this relief, I will put down here. And that's it. After this only comes, there is a last bit on caveat. Caveat is simply basically that, I don't know if this has been explained at some part, but in very simple words, if somebody files a caveat, I will have to inform them as soon as I have filed this petition. So for example, if somebody files a caveat against a certain order of the GCZMA, for example, and I go to appeal that order of the GCZMA, they will have to, when they file an application, even if I am not a party in their appeal, they will have to inform me that they have filed this appeal and give me a copy of the appeal. When I file a caveat, it's basically me saying that I have a certain right over this situation. So at the very least, I need to be informed when judicial action may be taken against that. So here, for example, no notice has been received about a caveat, so I don't have to serve anyone extra from my respondents and so on, and I can go ahead. And lastly, of course, I'll have my affidavit, which is basically the same as the N.G.T. Here again, I have to say that I have filed it in public interest, that I have no personal gain, private motive, or oblique reason for filing the PIL, that I am ready to pay the costs if the court feels that my public interest litigation was frivolous or has been filed for some non-bona fide considerations, which you should be very careful about when you're filing a PIL. And then whatever you've said in the paragraphs are true to your knowledge, or at least is legal information that you believe is true. And that's it. After this, you will have all of your annexures and so on. That is your High Court PIL as well as your Ngt application. Both of these have been shared with you. Feel free to use them, as I said. I think that's it. Yes. If there are any questions, you can ask me now. Okay. So first question, I think, is from Karan, which says, what is your opinion on the quality of the expert members on the Ngt? I mean, firstly, there are many expert members. From my experience, which I of course is limited based on my experience, the expert members, when I have appeared, have been pretty good, have sort of helped to direct the judicial members also, when certain technical aspects, say for example in environmental clearances and so on, may have been overlooked, they have pointed out these issues or explained, technically why it is important that every small thing should be complied with. So, I mean, I would think that quality is fine. There is, of course, a procedure by which they are appointed and so on. So, it may not be right for me to give any opinion per se. Also, my experience is limited, so I would rather not. Are personal reasons, example sickness, travel, etc., acceptable for condonation of delay? To an extent, yes, of course they would be. You would still have to maybe give evidence of the fact. If you're depending on how much delay you are claiming. If it's a few days here and there, and you say that you were sick, maybe the court will sort of look into that. But say, for example, the court can see. They will, of course, look at it in each factual situation. So in one situation where a sickness may have worked as an example, it may not work in another. If you cannot show that your delay was legitimate, your sickness was reasonable. Say if I just have a cold and a cough and I say that I can't come, then that may not be reasonable. But if I have a prolonged illness and I can't travel, or I've been hospitalized and I have evidence of that, of course, these can be looked at as legitimate reasons for condonation of delay. Is N.G.T not the correct court if there are violations of state environmental laws? I'm not sure if I understand this question, but very simply put, if it falls within the 7 laws that are listed in the schedule, you go to the N.G.T. Anything outside the purview of those 7 laws, you cannot go to the N.G.T. The N.G.T does not have jurisdiction over those. So for example, like I guess a state environmental law would be your Trees Act, your Goa's Preservation of Trees Act. While trees would come under an environmental issue, of course, you cannot go to the N.G.T for that. You will have to approach the High Court or the tree officer or whatever the legal provision under that act will be. What are the repercussions if an N.G.T order is not implemented on the ground? The N.G.T has the power to impose penalties on you. You can file what is called an execution application to the N.G.T if its orders are not being implemented. And you can seek redressal in that manner. The N.G.T, of course, has the power to issue some pecuniary damages or give some sort of punishment the same way that a high court would. So in that sense, the situation would be similar. In limitations, from which date exactly does the clock start ticking? So here, of course, it would again differ based on which section you are going under. So for example, if you see the wording of section 14, it says from the date on which the cause of action first arose, which would be then from the date on which the illegality first began, or at the very least from the date on which you came to know about the illegality. Now, if you come under section 15, again you have cause of action. But if you come under section 16, which is an appeal, your limitation period begins from the date on which you are communicated the order that you are appealing. So for example, if the order is passed today, but I get the copy via post or whatever 3 days from now, my limitation period or the clock per se for me will start ticking on that date. So the limitation period will differ in each of these situations. So see under which provision you are going to file and see what it says about the limitation period there. Did you win the N.G.T case in the example shown? It's a pending matter, so no, not yet. Is the N.G.T hearing cases virtually these days? Yes, it is. Very similar to how the High Court procedure is going on right now, where you e-file everything. The N.G.T, in fact, has been e-filing things from before the pandemic even began. Because as we know, the N.G.T bench, for example, in Pune for the Western Zone has not been properly functional for a really long time. So in that sense, you have to e-file, which is basically that you have to send them a soft copy of everything. Even the court fee is paid online. Everything is uploaded online. You have to make an online profile on the N.G.T website. You upload everything and then they give you a date, and then you have a virtual conference, the WebEx thing, which is exactly the same as the High Court. It's sort of like a Zoom session in a way, where you have the judges and your expert members on one side, and then you have all of the parties virtually fighting their case. Are the headings important? Points to be heard, issues to be considered. Important in the sense that your case will not be rejected per se, maybe if the headings are not there and the substance of what you're saying is there, but it will make things that much more difficult for you. When you're preparing for your case, it will be that much more difficult when you have to get your objections cleared from the registry, because the registry will check that each of these things, at least the substance of it, is there or not. Largely, at least from my experience, they will look for the headings being exactly where they are supposed to be. If they are not, they will raise it as an objection that you have not said so and so. And then it will be for you to go and show them that, okay, the heading is not there, but see, in this para I have said it, or in this para I have made this statement. So while it may not be a legal requirement per se to have a heading, I would always suggest that you do. Does the N.G.T cover issues which also involve constitutional violations? Probably not. I mean, if it comes as a part and parcel of an environmental violation, maybe. Like, of course, for example, you can say that right to clean environment is a part of Article 21. So that becomes a constitutional mandate. But you are approaching the N.G.T on the environmental grounds. But beyond that, anything outside of the environmental provisions that are a part of the Ngt Act, no, they will not. Do you handwrite the PIL number at the time of submitting the petition to the registry? The petition number is provided by the registry. So when I first file it, I leave it blank. I give in my petition. This is to the Ngt or to the High Court. I leave it blank first when I file it. I give it to the registry. At the time of filing, you will get a stamp number, which is basically like a temporary number. That number will be used when I'm communicating with the registry. Once I have cleared all the procedural requirements, which is basically that the registry has scrutinized my appeal or application or PIL, and they have found no defects, which is that all of my declarations are there, my petition is clear, it has the right amount of spacing, my annexures are all clear and all of that, then the registry will register my PIL or my application and give me a number. At that point of time, they will handwrite it on my court copy themselves. I will write it on my own copy, and thereafter, whenever I am printing my PIL or I am filing an affidavit or whatever, then I will, of course, type it in. But until then, you will have to handwrite it. But remember that we don't come up with the number. You don't, on your own, give yourself a PIL number. That number is given to you by the registry. Why don't all the acts relating to environmental issues, for example, the Biodiversity Act and the Goa Groundwater Act, come under the purview of the Ngt? The Biodiversity Act does come under the purview of the Ngt. The Goa Groundwater Act, however, does not. Why it does not, to be honest, I'm not completely sure on what basis the acts that fall within the schedule have been decided. But perhaps because, as Roshan said, perhaps because it's a state act, it does not come within the purview of the Ngt. But it's a good question. I will look into it, and if I come up with any other reasons, I'll get back to you. In the PIL, aren't you repeating informations in different parts of the petition? Yes. In some situations, you are repeating certain things. For example, it's like where you've made a representation and you've already annexed it, you will have to repeat it. That's there, but that's just the format and certain procedural requirements when you're filing documents of this nature. Is there a relatively simple way for non-lawyers to locate precedents? To be honest, these days it's quite simple. Google is your best friend, because literally if you just say, for example, if I'm looking for a precedent on, say, groundwater or illegal constructions or whatever, just put in your issue. Say CRZ, illegal construction, High Court or N.G.T. And usually what will happen is that if there is a big judgment, if there is an important judgment, or at least if there's something that courts are speaking about and articles have been written, that will all come up on Google. So you can sort of start over there and then get into specifics. So you may find, and it's sometimes fun to do research like this, where you just sort of Google your broad issue. You may find an article where this issue is being spoken about. In that article, they'll say that, recently the High Court has issued this judgment or this order. And from there, you can sort of go about finding it. If you want a more legal specific thing, you can go to this website called indiaqanun.com, which is a sort of simple, it's a pretty simple to access legal database of all judgments of the High Court, Supreme Court, sometimes even N.G.T, even Administrative Tribunal and stuff like that, where you go to India Kanun and the format is very simple, very similar to Google. So there's a search bar where you can put in whatever you want to search. You can even look for specific provisions of law and so on. And sometimes they'll show you what the provision of law is, and on the side, they'll show you cases that have used that provision of law. Or sometimes you look for a particular case on that website, and it will show you on top cited by. So it will show you other cases that have relied on this case and so on. So things like that, you can sort of narrow your search down. But India Kanun and Google are easy if you're not a lawyer. There are, of course, other legal databases, but they're slightly more complicated than these two. What is this public trust doctrine and where can I get it? The public trust doctrine is essentially like a principle of law. It basically states, and I mean, it is also the basis of a lot of laws in the country, which is basically to state that the government, a lot of public resources are, of course, as we know, they belong to the citizens, right? But they are managed by the government. They are kept in public trust with the government for safekeeping, to manage, to protect, to conserve for all of us. So that is the public trust doctrine, under which the state or the government is responsible for my resources, right? Public resources that all of us own, natural resources that all of us own. While each of us cannot go and individually claim responsibility and claim accountability over what is happening, we give it to the government and we trust that the government will take care of it. So that is the public trust doctrine. So if the government mismanages any of these resources, they mismanage what belongs to us, they are violating the public trust doctrine. It's not to get, I mean, it's a principle. Then, how is delay defined in the context of PILs? Like I said, the concept of delay when you're dealing with PILs, of course, is a slightly broader concept than with the Ngt Act or with other acts that specify what your limitation period will be. Even the Limitation Act, which otherwise would apply, is very loose when it comes to public interest litigation. So here, delay is largely in terms of either if you're challenging a specific order or something which comes under a specific act and there is a specific period of limitation provided, that would be one. But if there is none, then of course you're relying basically on logic and common sense to say that I have come to the court as soon as was possible. So not that I'm filing a public interest litigation so I can sort of sleep on it for a year or 2 years and then go to the court. For example, if I'm coming against an illegal construction, always better, and I know that whatever is happening is illegal, I should come to the court before anything starts. I can't say that, yes, I knew that this was going to happen, but I waited till they put up the entire building and now I have come to ask for demolition. So in that sense, then the court will say that I am barred by delay, right? So it will differ from case to case, and when you're filing PILs, it's slightly looser than, say, with the Ngt. Has the PIL-WP been decided in the High Court or is it pending? If till date, so please furnish the WP number. The PIL that I have provided you has been disposed of. It was PIL number, just give me 1 second. I'm not too sure of the PIL number that it was, but I'll provide that number. But in that case, it was disposed of by a final order because the government authorities that were there, which is basically your WRD, after we filed the petition, the WRD sort of got pushed into motion because of the petition, knowing that the court is watching, and they sort of dealt with all of the illegalities themselves. And once all of the illegalities were dealt with, the High Court disposed of that matter. If Mukesh Sawant is the violator of the Water Resources Act, why are the Water Resources Department, Electricity Department, Police Inspector and Government of Goa also listed as respondents in the PIL? That's a very good question. One is that when I am filing a public interest litigation, my reliefs that I am seeking are for the government to do something. When I am seeking, basically I am filing under writ jurisdiction. I am seeking the enforcement of a fundamental right that I have. That fundamental right is only enforceable from the government when I go to the court. So for that reason, my reliefs are not directly towards the private party. Which is why I also said that when you file a PIL, the state of Goa always has to be a party there. Now the reason why the Water Resources Department, Electricity Department, Police and Government of Goa are also listed is because these are all authorities that are in some way involved with the case. The WRD, of course, because I am dealing with a case of illegal groundwater extraction, and the WRD is the main authority, statutory authority there. I have here also the Electricity Department and the Police Inspector, because in this particular case, both of these departments had also gotten involved, because the WRD had written to the Electricity Department and the Police Department to cut the electricity or to take action or to lodge an FIR. So throughout my fact situation, if you can see, if you look at all of the documents that are enclosed, you will see how these departments were also involved in this case. So in that sense, I am also sort of pushing them to do what the WRD had asked them to do, or to be involved in whatever way. Next, can you please tell us a bit more about how bona fides are established? If you're talking about the bona fides of the petitioner, when you are approaching the court, it's pretty simple. Unless, the idea basically is that you are approaching the court with clean hands. Always remember that the court will look at your bona fides, based on your reputation. If there is no reputation per se to go by, they will go on how you conduct yourself in court, the things that you have said in your petition, that you aren't an extra cantankerous person, that you are coming here to claim a legitimate relief, and that's all you're doing here. When I say you're coming to the court with clean hands, this is very important, because you'll see in certain situations where people, are either complaining about illegal constructions for non-bona fide reasons, which is that you don't particularly actually care about the illegal construction or whatever, but you're doing it for revenge or for some extraneous reasons. Then the court is not likely to take that well. And what can happen is, the other thing is that if you have done any illegality yourself, then you are coming to the court with unclean hands, and the court will not entertain your petition or may even order costs imposed upon you. Like, for example, I've seen this happen in court where a certain party came as the petitioner in an alleged PIL to challenge some illegal construction that was happening by their neighbor. The neighbor now comes and says that I have not actually done any illegalities, but this petitioner themselves, their second floor is illegal and they have done this and so on. And then it just becomes a fight between these two people. There is no public interest actually being served. And because the petitioner has come with unclean hands, the High Court, of course, because it is a public interest litigation, the High Court in that situation asked the authority, what is the illegality or who is doing the illegality? When the authority said that both the parties have done something illegal, the High Court said, all right, and imposed costs and damages and punishments for both parties, the petitioner as well as the respondent. So, that's basically how you would, that's how you would not establish your bona fide. Sorry to answer your question in this reverse manner. But for most people, it's pretty simple. Until and unless you give the court to believe that you are not a bona fide person, it will be believed that you are bona fide. Can you please let me know the difference between a PIL and a writ petition? A writ petition is where you approach the court in its writ jurisdiction for the enforcement of a fundamental right, for any of the writs that I think ma'am has explained to you, habeas corpus or certiorari and all of that. A PIL is simply a writ petition that is being filed that is not for your own personal interest but in public interest. So when you're filing filing a writ petition for a larger issue that is going to affect, even if it does benefit you, but it also benefits the community at large, you can file it as a PIL instead of filing it just the writ petition. Which are the other parties indirectly involved before filing the caveat? I'm not sure if I understand that question. Next was the attempt to shift Goa's jurisdiction of NGT of Western region to Delhi for malified reasons finally shelved? I'm actually glad that you asked this question, because I meant to include this little story as a part of my presentation, but I skipped it. So I now have a chance to do that here. What happened was, in, I believe, around August 2017, like I explained, the territorial jurisdiction of of Goa for the NGT lies in the Western Zone, which is in Pune. In August 2017, the MOEF came out with a new notification, and they suddenly shifted Goa's jurisdiction from the Western bench to the principal bench, which is basically in Delhi. Now, after this notification came about, it would basically mean that everyone from Goa, if they want to approach the NGT, would have to go all the way to Delhi to fight their case. The reasoning that the government gave for this was completely absurd. They said that it was because there were too many cases coming from Goa, and that they did not have enough government lawyers in Pune, and all of their lawyers were in Delhi. So it would be easier for the government basically if the bench was shifted there. And yes, that was finally shelved because the Goa Foundation filed the case. Many other people filed writ petition, PILs, and in fact the High Court also took it up on its own. And all of those petitions were heard together. If you look at that judgment, there's a I think 4 to 5 pages long list of just how many petitions were filed, including the High Court's petition. And finally, the High Court, on grounds of the fact that everyone has to have access to redressal and access to these justice mechanisms, held that you cannot shift Goa's jurisdiction without any valid reason to Delhi, and it has been retained now in the Western Zone. Next, are there any disadvantages when you're making your case virtually as opposed to being physically present in court? Definitely yes. There are of course your basic issues like network connectivity. You don't know when that person can hear you, when you can hear that person. Everything is distorted. But of course, it is difficult to show documents when you're talking virtually. The only good thing right now is that everyone is sort of on a level playing field. Everyone is doing it virtually. So in that sense, it sort of balances out. But earlier, when the NGT was the only place that was doing virtual conferences, you would have people from Goa that were on virtual conference, and you would have people in Delhi that were physically present in court. Then you are definitely at a disadvantage. But I think maybe if everyone's over video conference, at least it's a level playing field. But it is definitely a lot harder to explain or to get your point across on this sort of a video conference setting than when you're there in person. Can one go to the NGT under the Wetland Act? No, because it's not specified in Schedule 1 of the Ngt Act. Then, don't you think that all relevant acts under the NGT require drastic change in view of the terrible consequences due to fast-changing climate change being experienced in Goa and rest of India? No, I don't think that all the relevant acts under the NGT require any drastic changes. You would have to see what is the issue in each of these acts. Some of the acts, of course, could be made stronger. For example, the EI notification, and not diluted like it has been in the new notification. But I don't know if a blanket statement like this may be necessary. In your PIL example, should you also not ask for some action to be taken against police for not filing FIR? You can ask for it, but largely when you're filing a PIL, the court will look at how your issue can be resolved. If the police had not filed an FIR for a really long time, or if you can prove that there is some specific issue with the police, then maybe they'll look at something like that. But in that case, it was not so. Oh, one more. Do you know if there are plans to continue virtual hearings after the pandemic is over? No, I don't think so. Yeah, I think that's it.